Hello, my name's Claire Murray. I'm managing partner of a specialist partnership, employment and SRA regulatory firm, CM Murray. And I'm joined today by my regulatory partner, Andrew Pavlovic. Hi, Andrew.
Hello.
We're going to talk about the last year. It's been a year since the SRA introduced new rules on workplace culture. And also, there have been some really interesting decisions come from the STT, which are related directly or indirectly to workplace culture too. So we just thought this was a really timely opportunity to look back at the last year and some of the highlights or the lowlights, depending on how you look at it. So, Andrew, do you think you could just give us a very brief summary of what the rules say and why the SRA introduced them into the codes of conduct, please?
The rule in the Code of Conduct for individuals is you treat colleagues fairly and with respect. You do not bully, harass, or discriminate unfairly against them. And if you're a manager or a partner, you challenge behaviour that does not meet this standard. And there's an equivalent provision in the Code of Conduct for firms, which requires firms to ensure that all employees meet that standard as well. And this was brought in for a couple of reasons. Firstly, prior to this rule, there was nothing in the code which said anything about how individuals and firms should treat colleagues. And that meant when you did have an incident arising in the workplace, you were having to look at existing rules and principles which weren't particularly relevant. So you had rules around not taking unfair advantage of others, for example, but there was nothing explicitly in relation to colleagues, as I said, so it made it a bit clunky and difficult to apply. And then secondly, there's a concern, and this is something that's been highlighted by the SRA in their workplace environment thematic review, that whether people are working in a toxic working environment where they're subject to bullying or harassment or being put under pressure, they're more likely to A, make mistakes, but B, also potentially do something to cover up those mistakes. And that results in poor outcomes for clients.
We've talked about this before, haven't we? That actually the starting point is sort of protecting the consumer and upholding, the public confidence in the provision of legal services. That's sort of front and centre, and everything flows from that. And when you start to look at the rules from that perspective, it does make a difference in how you view them. So, what have firms been doing over the last year to address these new rules?
Yes, well, we've seen a lot of training. And training has been focused on sort of different areas of the firm. So as I said, the obligation to challenge behaviour only applies to partners. So some firms have really focused on training for partners, particularly around challenging. How do I challenge? When do I challenge? What do I do after I've challenged in terms of who do I tell, who do I notify, etc.
I guess, and the report and the recording of that.
Yes, and recording, and that's been a particularly sort of contentious aspect of the guidance in terms of does every single challenge need to be recorded? The SRA, the guidance suggests that it does, albeit Julia Oliver has told us that the guidance is a bit, it's not very subtle in that regard, and they
Julia,
may be looking at changing it.
sorry, Julia
Um,
Oliver, just for the layperson, Julia Oliver being,
the SRA's General Counsel.
yeah, thank you.
So recording has been something that we've been looking at when we've been looking more at the partner training. And then alongside that, there's been training for other fee earners and business support staff because other fee earners still have the obligation to treat colleagues fairly and with respect, and they need to know the circumstances in which their behaviour could be challenged. And for support staff, obviously, as I said, the firm requirement is to ensure that all employees meet the standards. So everyone needs to know what the standards are. So training has been a big part of it, as well as policies. So some firms have introduced specific policies around unfair treatment and these new rules, providing guidance on when to challenge, how to challenge, all the things that we've just talked about, really, in terms of the training. Others have amended existing policies around perhaps sexual misconduct or anti-harassment, just to incorporate this requirement to challenge behaviour. So there's been a differing approach in terms of policies.
And I think we've certainly seen some firms being very explicit that if you don't challenge and report as a partner, that in itself may be treated as an act of misconduct and could result in disciplinary consequences for you as the effective bystander who didn't intervene. So there are, as not just regulatory, but also potential sort of partnership status consequences as well.
Yeah, and we have actually seen some policies which already required that from a disciplinary perspective prior to the introduction of the new rules anyway. They already said that partners should be challenging these sorts of behaviours.
When you're speaking to different partner groups about these new rules and the steps to be taken, what are the issues or the kind of concerns that are being expressed?
I think one of the concerns that arises quite frequently is that obviously the obligation to report matters to the SRA or to the CULP if you're a partner can in fact inhibit the internal reporting of issues. So we always say to partners that, don't overpromise on confidentiality. If someone comes to speak to you and says, "Can I have a word in private?" You need to be very clear that there are some things that you might have to escalate depending on what you're told.
Mm.
And when we speak to partners about that, we do sometimes get the comments coming back to us, well, people think that every time they tell someone something that's going to result in a big investigation or the SRA being notified, they just won't tell us at all. And actually it will have the opposite effect, and people will keep things to themselves because they know it could lead to something that goes out of their control. And obviously we try and say, well, keeping things to yourself isn't really helpful from the firm perspective. Trying to deal with things confidentially doesn't give the firm the knowledge it needs to deal with issues. And these rules are there to empower you in a way so you don't have to deal with all of these things yourself. And you can pass them on to people who are better placed to make judgments about whether things should be reported, such as the CULP. Do you get that feedback that actually people won't tell us things because they don't want to be involved in a lengthy SRA investigation? They just want a particular piece of behaviour to stop.
Yeah. So it's kind of how you handle that. But I do also think that another chilling effect can be if people do report up and there is an investigation, but then nothing seems to change. I think that can be, yeah, as chilling effect as as the risk of an investigation at all. But there are obviously reassurances and confidentiality commitments that you can give to a certain extent. Is there any other sort of feedback that you're getting as part of the partner training?
Yes, I mean, we've already spoken about the sort of need to notify people about once you've challenged behaviours, and how some partners have said, well, that takes the sort of informality out of the situation. If I wanted to challenge behaviour by just pulling someone to the side after a meeting and saying, I think you went a little bit too far there, I think most partners said they would feel comfortable doing that. But then if they then had to email someone or in HR or risk and compliance or the COLP or whoever it is, that would sort of take the informality out of it and make it a more formal issue. And again, we have the guidance which we just talked about, which says that after challenging behaviours, an individual should consider how they should record the challenge and the action taken. So the guidance is definitely steering you towards taking a note or recording what's happened. And the risk to a partner just recording the challenge themselves, i.e. sending an email to themselves, is that doesn't give the firm the knowledge to perhaps deal with a repeat offender if the partners are just challenging and then recording that and keeping that to themselves. So that has been a difficult issue because, as I say, people don't necessarily want to have to be telling everyone. They're quite comfortable with giving someone a message, but then they feel that having to then go and tell everyone that they've done that is adding an additional layer of formality to it.
But the point is that, I mean, a lot of firms do, and a lot of, teams do operate in silos, and there's not enough sort of, for one reason or another, management oversight or kind of intervention into teams, which means that if someone does intervene and say something but doesn't escalate it through recognized confidential channels, then the people who need to know and need to join up the dots can't. The risk is that the behavioral issues continue. So it really is a challenge, isn't it? So what is the SRA doing to monitor compliance with these new rules?
Yeah, so they've been visiting relationship manager firms to collect data on sort of the number of workplace incidents and how those incidents have been resolved, and also just generally to understand how firms deal with incidents when they arise in the workplace, what they do to monitor well-being, and what they do to monitor mental health concerns. And all of that information is going to be collated and reported back, we think, in the form of a thematic review later this year.
Right.
So the purpose of that thematic review would just be to sort of give examples of good practice in terms of dealing with incidents. And also, I think to just give a flavour of the sorts of things that they've had reported to them since the rules came in last April.
So that'll be something to look out for and some clearer guidance as well.
Yeah.
That's even though I know for those firms it can be perhaps a little bit, nervous making at the time when they're receiving those visits.
It's supposed to be quite a threat. It's not supposed to be delving into particular incidents or a chance for the SRA to go into that. It's more of a general sort of fact-finding exercise. And as I say, it's targeted at all firms that have relationship managers. So I don't believe any firms are being singled out.
Right. Oh, that's interesting. So I don't think we've seen any cases coming through yet that are on the back of the obligation to challenge and ensuring that you treat your staff fairly. No sort of SDT decisions, but there have been some sort of really interesting and instructive cases, SDT decisions over the last year on workplace related issues and proximity issues. And I know there were sort of 3 or 4 that you wanted to briefly just highlight. Do you want to just give us a kind of like the edited highlights of that small handful of cases?
Yeah, so firstly, yes, you're right to say there's been no SRA decision or tribunal judgment in relation to the new rules. And in reality, that might take some time, given the length of time it takes the SRA to investigate concerns, and then if the matter was to be referred to the tribunal, then there'd be a hearing. So it could be a couple of years before we get a tribunal judgment on the new rules. But in terms of other cases, we've seen quite a few cases that are of interest and would have application to the new rules. So one is a case of Bhatia, who was a solicitor at a firm that was found to have unfairly discriminated against an employee on the grounds of maternity. So the Employment Tribunal made an adverse finding against the firm. And the SRA, relying on that tribunal finding, took the case to the Solicitors Disciplinary Tribunal and said that Mr. Bhatia had acted in a way which breached the relevant SRA principles. And what was interesting about that case is that the Solicitors Disciplinary Tribunal said that they weren't bound by the Employment Tribunal's findings. They heard the evidence themselves and found that, in fact, Mr. Bhatia hadn't unfairly discriminated. So they came to an opposite view to the Employment Tribunal. So he
Did
was
they give any basis on which they reached that? I mean, it
as I
seems
said,
a little surprising, but
well, you would expect you would expect them to have had more deference to a specialist employment tribunal, but as I say, they effectively reheard the case on the facts and came to a different conclusion.
interesting.
He was, however, reprimanded because after the employment tribunal had published their findings, he failed to notify the SRA that the firm had been found to have discriminated.
Right. And so what do we take from that case then?
What we take from that case, I guess, is that the SRA won't just be able to piggyback on the back of employment tribunal findings. So even a finding made in the employment tribunal wouldn't easily translate into a case in the Solicitors Disciplinary Tribunal.
Okay. I know there've been obviously some high profile sexual harassment SDT decisions over the last year, and I think you were going to mention a couple of those.
Yes, we've had 2 partners struck off in the last year. but sexual misconduct and obviously quite extreme sets of facts in both instances, but both sexually motivated behaviour involving juniors, clear abuse of power and abuse of position. So hopefully quite exceptional in terms of the sort of the severity of the allegations. But in both judgments, there is reference to the fact that other individuals within those firms might have been able to pick up that there was something inappropriate going on. Not that they would have been in any way aware of the degree of what was happening, but there might have been signs that the relationship was perhaps a bit too close for comfort in one of the cases involving a partner and a paralegal. And it's interesting to think about how that case would have played out under the new rules,
Mm.
whether someone seeing a partner and a paralegal engaging in that way might have considered that they needed to challenge that behaviour in the moment. And if they had, whether the sort of issues would have been brought to light sooner.
And you can certainly see situations where the sort of alleged victim would say, X and Y were in the room, or they were in
Mm,
at least in the vicinity, and they saw what was going on and they did nothing.
mm,
Or they saw me crying afterwards and they did nothing. They weren't curious.
mm.
Um, and that might result in a regulatory issue for them under these new rules.
Yeah, absolutely.
And then I think there's another case, a really interesting, very recent one to do with sort of, social media and expressing extremely polarized views on the part of a solicitor.
So this was a solicitor who was struck off the roll for anti-Semitic posting anti-Semitic tweets um, directed at other individuals, and this this was an interesting case, and these cases are always interesting because they raise these issues around freedom of expression, the extent to which people should be able to express their views, and how that's brought into conflict with the need to uphold the public confidence in the profession. So from a sort of proximity to practice perspective, the fact that he'd identified himself as a solicitor was how the SRA were able to say he wasn't just tweeting as a private individual. So that does sort of raise a number of issues in terms of whether someone, for example, who hadn't identified himself as a solicitor in their profile, but hadn't anonymized their profile, so someone could Google them and find out they were a solicitor, whether that would still be something that was caught, or it would
What do
still
you,
be considered to be proximate to practice. I think it probably would be.
I mean, it's so easy to find out someone's background, isn't it, these
Mm.
days? Um, yeah.
So it does open up all of these issues that we've seen in other contexts, from Beckwith and all of the cases around proximity to practice and how that applies to something like this, conduct outside the workplace. But I think in this case, there were a number of tweets, and also when the SRA began investigating him, he also subjected them to abuse as well. So a strike off, although it seems quite extreme in context of other sanctions we've seen from other regulators for social media conduct, I think it probably was justified in this instance.
Thanks so much, Andrew. So if there was sort of one, I guess, one big theme then, or recommendation that you would have coming out of the changes a year ago and the recent cases, what for firms, what would they be?
Yeah, I think certainly firms shouldn't have feel that having done the training, updated the policies, that that's the end of the matter. It's an ongoing discussion, it's an ongoing review, it's making clear to staff that they do have channels to report things, it's making clear to partners that they should be challenging. So it's obviously great if firms have done their training, they've updated their policies, but it's really just thinking about how we can deal with matters and reinforce these behaviours on an almost daily basis. Because clearly the SRA are going to be investigating these issues. We're going to have more light shed on the sorts of cases they're interested in when this thematic review is published in later in the year. But I guess that's the main takeaway from me is great for firms have taken the steps. That's what they should have done. But there's clearly it's an ongoing battle and one that the SRA are clearly not going to be forgetting about anytime soon.
Yeah, no, I mean they're really assertive on these issues, and
Yeah.
I know there are different views on how people feel about that, if they think the SRA is going too far, or if this is appropriate. I mean, what it's certainly aimed to do is to affect change.
Mm.
Um, these are really difficult issues. They're usually difficult cases, and there are issues around trust, around communication, around conflict, around relationships. I mean, it's all the stuff of humanity, and so they're not easy. And I do think the SRA is trying to at least bring some overview and encouraging firms to bring some oversight to ensure that people are protected and working in a safe environment. So look, thank you so much. That was really interesting. I really enjoyed that. And I hope if you've managed to stay with us to the end that you found this interesting and helpful too. Obviously, we just literally skimmed the surface of it. We love these issues. We really talk about them a lot within our team and with our clients and in the market. And if you have any questions or concerns or would just like to debate some of these things with us, please do always feel free to get in touch. We'd love to hear from you. Andrew's very keen to hear from you as well. And but thank you so much. I hope you've enjoyed it and see you soon. Thank you. Goodbye.
Bye.